Well, this week, maybe you heard about it. Disney changed their tune. This regarding a wrongful death lawsuit that was brought about after a woman died after she ate at a Disney resort restaurant.
Originally, they said the plaintiff couldn't sue because of the release he signed with Disney+. Our 9 News legal analyst, Whitney Traylor, is joining us now to join on this discussion. This case is really super interesting because most of us are thinking Disney Plus and Disney properties, but then there's also the difference between arbitration and going to trial, and I don't think most of us understand that.
Yeah, and that's a big difference, and that's an important issue because a lot of times we sign documents, we engage in endeavors that we've actually agreed to arbitration. And so arbitration is essentially where you're saying, we're not going to get a jury, we're not going to get a judge, we're going to get an arbiter, and it's a private event. And so a lot of companies will have what's called mandatory arbitration provisions. And we've had a lot of legislation, a lot of politicians trying to move towards getting away from mandatory arbitration provisions. But if for example, if you go skiing, your ski ticket will say,
check the box.
If there's an issue, you're going to arbitration. And so here, what the issue was you're not going to get to a jury, you're going to go to arbitration. So that's a common issue in our current society.
Talk about Disney's decision, though, to not stick to that, the letter of the law, where they might have been able to wriggle from this. Instead, I mean, I don't know what they're going to end up paying in this case if they do settle. But the bad publicity of them sticking people with a Disney Plus agreement, something you checked on a box when you wanted to watch, you know, Mulan. And all of a sudden you can't sue them for something that happened somewhere else. It seems like a sound decision, if you will, topically, for me to look at it and go, they did the right thing.
Right. As a defendant, that's part of the issue because you're saying, hey, we don't want this bad publicity, even though as a legal matter we could actually do it. And so that's part of the issue is whether you push forward on this defense of saying, hey, we can go to arbitration, because if you go to arbitration, the defendant a lot of times gets to choose the arbiter, and that's usually a former judge. It's somebody that works for them. I'm not necessarily saying that they're going to be biased and they're going to rule just in favor of the defendant, but it is favorable in many regards. I mean, if you're looking at a situation like this where somebody passed away because of something that they ate, are you wanting a jury of your peers, people like you and I, or do you want an arbiter who you have chosen? So, you know, that's part of the issue.
So with these things, these boxes we all check without reading.
Right.
I know you as an attorney would say, oh, you should always read those.
Of course.
You should always read that top to bottom. Do you read those top to bottom? Do you just check that box? Because, I mean, nobody's going to read it. But you have to check it, right?
I won't speak for myself. Those are called click wraps and shrink wraps, and that's a very legitimate question. Do we read those? Should we read those? The answer is yes, you should read them. Is it realistic? No, it's not at all. Because there was actually an article that said it would take 2.5 hours to read and understand those. And even if you read it, you wouldn't really understand it. And you probably wouldn't have the ability to say, hey, I don't agree with provision 6.
I've written some edits in.
Yes, exactly.
I'd like some changes.
I mean, like you don't get to do whatever you want to do.
Right. You don't get to make these changes. And so it's sort of a take it or leave it, which is called an adhesion contract, which is another way to argue against it. So, no, these things are difficult. But at the same time, it's if you want to go to the amusement park, if you want to leave your car in the parking lot and all these other things, should you be able to? And that's an issue. And so here, I think Disney, I think it was not so much the legality, I think it was the publicity. Because from a legal perspective, I think they actually had an argument.
They had a good case,
well, they can still fight the case, but they're going to allow it to go forward now.
Right. Well, but they're allowing it to go forward to a potential jury as opposed to arbitration, which, you know, do you want a jury of your peers or do you want an arbiter? And a lot of times the defendants just want the one arbiter who they have selected, who they're actually paying, who's actually on their payroll, as opposed to a jury of their peers.
Think of trying to find peers for Kim. I mean, she's peerless.
Right. I mean, she is peerless.
They have no chance.
There you go.
No chance whatsoever.
Yes.
Whitney, thanks for talking about this with us.
For sure. Good to
Appreciate
be
it.
here.